to introduce our panelists to discuss the recently released paper on the digital economy and competition by the Commission. We have an outstanding panel today. So first, I just want to thank the Commission for affording us this opportunity to co-host a discussion on this important paper with the Commission as the Mandela Institute. So I'll introduce our panelists. First, it's my pleasure to introduce Hardin Ratshisusu, who's the Deputy Commissioner of the Competition Commission. Thank you for participating in this event. And then our other panelists are first of all, Professor Liberty Dube, who's the Associate Professor of Economics and Finance at Wits University and a former Chief Economist of the Competition Commission. Professor Klaaren is a colleague in the law school whose expertise, amongst others, includes competition law. Xolani Nyali, who is a partner in a Johannesburg law firm, Bowmans, and practices competition law with a particular interest in the impact of disruptive technologies. And Dr. Alastair Tempest, who is the CEO of the Ecommerce Forum Africa. The panel will be presided over today by a judge of the High Court, Norman, who is used to presiding, and who happens to be also a former director of the Mandela Institute. So I'm trying to fill his rather large boots, and who served for 20 years on the Competition Tribunal. So over to you, Norman.
Feroz, thanks very much. What we were going to do was to start off with Hardin, the Ratshisusu, the Deputy Commissioner, just to give a brief introduction to the document and the points of emphasis that the Commission would like to give us before we go on to the panel discussion. So, Hardin, if we can just hand over to you briefly then.
Thank you, Norman. Feroz, and indeed it's a pleasure to host this event, to host this seminar, webinar with the Mandela Institute. I hope now you can see the screen. I've shared my screen. Thank you. I will just give a very brief presentation of the paper that we have published, but also highlight some of the developments that have informed this approach. It is indeed a fact out there that there are changes in the global economy from these technologies. The fourth industrial revolution is to enable new technologies. We are seeing a rise of digitization. And this is something that in the competition fraternity, it's something we discussed even, I think, around 5 years ago in the international competition network, where we had a special project on vertical restraints in online markets. We, as the Commission, and following, of course, major jurisdictions around the world, you know what has been happening here in Europe, US, we then thought it's appropriate that we publish a strategy paper, because what is clear here is that the challenges we face will require multi-pronged solutions. We work with a number of regulators to deal with these issues. As I've said, we are following mostly what's happening in the EU, Kenya, Australia, and what the OECD and UNCTAD have been championing, requiring authorities to respond to the changes in the digital space and the rise of digital platforms. We have seen enforcement of these cases in Europe through the European Commission, the Google shopping cases that many of you are familiar with, Google Android cases. We have seen recently cases against Amazon in relation to how they manage their marketplace seller data. The Australian Competition Commission, in fact, has a Competition and Consumer Commission, has done an inquiry, but it's also looking into publishing a code. So it has focused in the first phase on the advertising markets and targeted the conduct of Facebook and Google, in Australia, to address the bargaining power imbalance. So there is a code in Australia. So these are the developments that we have seen. The main focus of areas of this draft strategy, and we have picked up that there's a lagged regulatory response. The markets are evolving quite fast, so we need to find a way of responding to these challenges. The markets are growing at a very rapid rate. There is a potential for market abuse by large digital platforms, especially as these markets are characterized by network effects. So I'm sure we'll hear a lot from the panelists about this. There's potential again for killer acquisitions that remove manual fence. Potential collusion in digital markets through algorithms. Not that algorithms, artificial intelligence is bad, can be very good. We are seeing a whole lot of efficiencies out of this. But this is something that we look at and are conscious of as authorities. There's consumer protection on the use of personal data. Although the Competition Commission focuses on competition issues, we are seeing other challenges that also touch on consumer protection. So we think it's important that we bring in all role players in tackling these challenges, especially even the newly established information regulator. We have also been looking at the impact of these markets, digital markets, in the broad architecture of the industrial structure of the economy. So we think it's quite important for us to have a strategy, not just looking at short-term enforcement action, but also long-term, what would we like to see for South Africa, but also for the continent of Africa as we have it, as we are moving towards integration. We believe there is a contestable digital space for local firms to take part in, and to preserve this, the Commission intends to map the local digital landscape in order to inform proactive initiations on market conduct by dominant firms, and to focus on future market inquiries or research in these areas. And this is where I think the partnership with the Mandela Institute is quite important, and we are quite grateful that we will be working together moving forwards on this. Proactively investigate conduct by dominant online platforms that may be exclusionary. We would look at very carefully at measures in the space, especially creeping acquisitions. We'll issue guidelines where appropriate, do scoping studies, impact studies, and I've said market inquiries, but more importantly, cooperate and coordinate with other competition agencies, both locally and elsewhere. Advocate for pro-competitive and pro-challenger firms sort of regulatory response, because we think it's quite important that as these markets grow, there is participation by small and medium-sized enterprises in South Africa. And moving into the future, what ought to be our priorities? This is what we put out there. It's out for discussion, and we do welcome input. We would prioritize digital markets like many other authorities globally. We would have to work closely with the regulators in the space, ICASA, National Consumer Commission, and the Information Regulator. Targeted advocacy to ensure digital markets are a policy priority, although already this is a priority for government. We know there is a 4IR commission at the presidential level that's also looking into this. Regulate for inclusive participation in digital markets, especially by SMEs and challenger firms. Ensure markets promote competition, innovation, and growth. Why we say this? Because we want to intervene in the manner that promotes innovation. We wouldn't want to be the ones to stifle the innovation we see in South Africa. And what are the next steps? As the paper is out, there is a draft. We are considering submissions and input into the digital strategy. So we have written submissions, but also a platform like this does allow us to receive feedback on what we have. Currently, we have to respond to measures in this space. We are looking at Google Fitbit. We have blocked NASPAR's We Buy Cars transaction in the space. And we are also investigating potential abuses in this space. And there are some cases that we are looking at. We hope to publish the final digital strategy by March 2021. And what is clear to us, and having listened to authorities globally, leading experts in the area, including experts we're going to hear from today, it's no longer about the why. Why do we have to look into this market? It's the how. How do we do this? Do we have to regulate? Do we have to enforce? What exactly should we do? And I look forward to the discussions, Norman, with the panelists. With just brief remarks, I thought I should introduce the paper in this way. So thank you very much.
Thank you. Hardin, thank you very much. That was a very, very good and succinct introduction. And if I may say so, congratulations to the Commission on producing such a thorough piece of work that you've done here. I think it's a lot for people to digest and get some idea of the issues. It's very helpful in the sense that you put all the debates, I think, quite fairly for people to look at. And I noticed then that you were saying you're trying to finalize this by, I think it was March 2021. Is that correct? So hopefully people who are here and who are interested, we've got a lot of people on the call. We've got 60 people at the moment. These are people who may have ideas and put them to the Commission. And it's great that the Commission is being transparent about these issues in the way that you're doing it. Now, let me make a confession. I've been in this game of competition law for about 21 years. And when I started, life was very different. If you wanted to catch a taxi, you stood in the street and you put your hand up and a taxi stopped. If you wouldn't ever let your house or your flat out to a complete stranger from overseas, you wouldn't dream of it. And if you had friends, these are people whose hands you shook or who you hugged. They weren't anonymous. That's all changed. Well, so has competition law changed. When I started, when we talked about cartels, we talked about people who met in the same smoke-filled room and struck a deal. Usually they had to write a lot of information down on a piece of paper, and that's often how they actually got caught. When we talked about a dominant firm, we talked about a firm whose prices were so high, they weren't disciplined by the other market players. So price was the way of really saying, these guys must be dominant. When we talked about mergers, we talked about one big guy merging with almost the next big guy, and that's what we saw as a problem in the market. Well, like the taxi and like the hotel, that's all, and the friend, that's all changed now in the digital world. It's been disrupted. People who want to collude buy packages with the same algorithms. They never have to meet, they never have to take notes. Dominant firms, or what we think are dominant firms, are firms who are supplying their services not at a high price, not at a market price. They're giving them away for free. And when we talk about mergers, we are not so much worried about the second biggest guy in the room. We're worried about the 17-year-old and his mate who started a firm in a garage and maybe the next Instagram, the next Facebook. So we're looking very, very differently at these issues. In short, just as much business has been disrupted by innovation in the digital market, so has competition law and regulation. So with that introduction, let me then start off with our panel who've been introduced to you. So perhaps let me start with Jonathan. Jonathan, the Commission, in at least two places when it's dealing with mergers and it's dealing with abusive dominance, is acknowledging that a lot of these firms are big guys who are located outside of our jurisdiction, but may have effects within our jurisdiction, and have sufficient firepower that if we would try to regulate them, either their mergers or their abusive dominance, they are equally can threaten us back and saying, actually, you want to do this, you won't have our product in our market. You Google, we're Fitbit. You're the Commission, we're Google and Fitbit. You want to mess with our merger, goodbye to all the Fitbits in this market. And all the runners and fitness fanatics will descend on Commissioner Bonakeli and Deputy Commissioner Ratshisusu and complain. So, and the Commission is quite frank. It says in its report that there have been firms that have threatened to stop doing business in South Africa if any action is taken against them. So what does a competition authority do? Is the Commission having a mature and pragmatic approach to acknowledging these problems? Or should it, you've got administrative law and a constitutional background, what should it be doing about handling the situation?
Okay.
Jonathan, thanks.
Yeah, thanks very much for that question, Norman, and for structuring this event. Thanks to Mandela Institute, the Commission, for hosting this, and I'm looking forward to hearing from the panelists and audience members on this, really important topic. So, on the question, I guess actually my answer is pretty clear on that, I think the Commission, and I would say this even if the Deputy Commissioner weren't here and were part of hosting it, that it is, in my view, a pragmatic and mature approach. It should be seen as a healthy dose of regulatory realism, in my view, rather than as any capitulation or anything like that. I think, and we've already heard a little bit about it, the threats are real, the threats of exit. And what comes along with that is losing the positive benefits of the disruption, of the manifold movements forward in the economy that come from digital. And I think competition is very good at recognizing those benefits of innovation, et cetera. So these firms are big, and when they say they could exit, they're not playing around. And to deepen a little bit, an episode that the Deputy Commissioner touched upon in Australia, where there are serious proposals there to have the Googles and the Facebooks pay the media companies, addressing the balance there for carrying their stories, or at least be forced to negotiate about paying for carrying those stories. You know, there's a real threat of exit there. So yeah, so that's serious. I think it's important also to note that the firms, however, in this space are not all of that stature. They might be giants, but of different heights. So, you know, there are plenty of more medium firms with digital platforms that may not have quite the same. So I think we'll hear more about this later, but many of the current direct strategies, I think, should work, the current notification standards, et cetera. And I think arguably the Commission's recent We Buy Cars merger, for instance, case is an example of that. But yeah, on the whole, I think the complementary and alternative strategies to the more direct enforcement approach, which the Deputy Commissioner in the paper mentions around, for instance, coordination of regulators, both, and I think maybe we'll talk more about this, both domestically and globally and transnationally, are important. Strategies like guidance and practice notes, and actually just the articulation of this policy paper. Doing some research a while ago, I was looking, you know, the UK, the US, Australia. This paper is deep. It's got real research. It sets out a position. It fits in that orbit of the Furman Commission, et cetera, et cetera. It's a good thing to see, and it'll have, I think, influence. So yeah, the last point I'll mention here is I think we really see this document as it's presented. I see it as it's presented, which is to say an instrument of competition policy. So certainly when we're teaching our students, Prof. Mncube shares his economic insights in our competition law master's class at BITS, for instance. Even then, we're really talking more about competition law enforcement and understanding that as policy. But I think here, this paper is really a policy instrument, and in the sense of its discussion of the issues and its charting of the various ways forward. So the questions for me are about, to what extent will other key economic policy setting institutions of the South African state take this paper, read this paper, take this paper on board and align with it. And also, to some extent, the actors who work, especially in that kind of private-public space, setting up municipal backbone infrastructures, et cetera. To what extent do they understand the imperatives of the competition, the competitive state in this new digital economy? So yeah, I've got actually one question that I hope either the Deputy Commissioner or others may answer as we go through the rest of the session, which is, yeah, we're talking about a final paper on March 2021, but both from the point of view of this being a policy document, I'm really interested in to what extent it's a living document, especially in this fast-moving area. So be interested to hear more about how the comments are incorporated. It may not be appropriate to call it a final document, even in March next year, that it keeps going. So that's just a thought, but thank you.
Okay, Jonathan, thank you. Hardin, I don't know if you want to respond just to that particular question that Jonathan raises now. This might be the best time to do that. I know that you're not on the panel and we're not paying you to answer questions, but it is useful for people who want to make submissions.
Thank you, Norman, and Jonathan, thanks for the question. I know you are couching this as a policy. We say it's a strategy, and I think it's quite important that we position it as a strategy. It's a strategy. It's not necessarily binding. It's just showing the path that we would like to take as the Commission, and we have sort of looked at how other authorities have done this. And you are right, we're just looking at a milestone by end of March. And then obviously this is an an ever-changing market, and we will review this on an ongoing basis. But it's just to give some certainty to the market on the kinds of issues that we would look at as the Commission.
Great, thanks, Hardin. Okay, if I can now go to Liberty. Liberty, if we can just see where you are. Thanks. You can just put on your video, Liberty.
Okay, I hope you can see me.
Yes. Okay, we can see you well. Liberty, you were once upon a time the chief economist of the Commission, and the paper makes the following observation about mergers. It says that the legislative regime at the moment is adequate to enable higher level of scrutiny of digital mergers, but the practical approach might differ as to how they want to analyze them. I know that in the Furman Commission, which was being mentioned earlier, and did a report for the UK Competition Authority, they suggested what was called a balance of harms test for digital mergers. In other words, as I understand it, you would say, well, let's evaluate instead of looking for a general test of substantial lessening of competition, you would say, what's the harm to the merging parties if we stop the merger? What's the harm to the consumer or to the general public if we allow the merger? In other words, it's a different form of analysis. Do you think that test is a better one? And although it's shifting you onto the terrain of lawyers, do you think that the existing legislation would allow that approach if it's a good approach? Or do you think there needs to be an amendment? I know we're shifting you out of your comfort zone, but you've been in tribunal hearings long enough to be a bit of a lawyer yourself. So what's your view on that?
Thanks, Norman. Thanks to the Mandela Institute and to VETS. You are right. In my past life, as an enforcer, I did just try to engage with some of these legal challenges, but now I think I'm much more reflective as an academic, and sometimes as a practitioner, I venture beyond my own comfort zone. But I think to answer the questions that you've posed in terms of the existing framework, I must make some reflections about where we stand. And to me, the starting point in all of this is to say, has there been under-enforcement in major policy relating to digital markets in South Africa? I do not think so, but I think we must keep a watchful eye. And if one looks back in time from 2015 and looks at the Takealot Kalahari merger, significant market shares, but countervailing buyer power wins the day. There are concerns about employment, and the merger is approved. Microsoft, LinkedIn were all, mergers that didn't raise problems. Facebook, WhatsApp didn't raise problems. MIH Auto Trader, again, significant market shares, significant barriers to entry, but countervailing buyer power also wins the day. Then, as mentioned, MIH We Buy Cars gets prohibited on concerns around potential competition. So the natural question for me is to say, does this record point to a particular hit or misfire? Does this record show any under-enforcement? I do not think so. Should the Takealot Kalahari merger have been prohibited? Open question. The evidence suggested no, but I think we can debate that. And then we get to a point of, should South Africa think carefully about its turnover-based thresholds of notification for mergers? Again, I would say definitely no. This suggestion of changing thresholds for notification of small mergers comes from jurisdictions with a different framework. I know Germany has moved towards value-based thresholds. There are two observations, and I think the Commission is on point on this point. First, it acknowledges that in South African setting, a firm may require parties to notify small mergers, and that the Commission itself can require parties to notify a small merger if there's an investigation or if it's concerned that digital markets are a problem, we can just prioritize that and require notification. So we are in a framework where there is no significant need to change major thresholds. Then I get to the question you've really asked me, which is, the issue about presumptions. Should we think carefully about the legal presumption against acquisitions by large digital companies? And should we change the burden of proof towards the parties? Again, I say no, but I think we should increase our enforcement activities. So if one were to think about the idea that's calling for a revision in terms of how we think about the law, it's coming from a concern that a merger with a uniquely qualified future competitor should be presumed unlawful. That's not particularly controversial in itself. The problem, of course, is identifying that uniquely likely future competitor. In digital markets, this can be very complicated because business models are extremely hard to predict. Industry participants also do not know what the industry is going to look like tomorrow. So while I accept that the Commission may have a symmetric disadvantage in terms of information and resources and knowledge of these markets, I don't think one should be thinking about changing the framework as is currently. I think that would, bring a huge opportunity cost, and it would make it may create a strong bias towards the Commission, and set a very high bar for parties. In any event, not just in South Africa, also not just in digital markets, many measures are approved or conditionally approved once the problems have been identified and fixed. Hardin spoke about, he mentioned the issue of merger creep, and that they would bring something out soon. I think that, again, is something that's interesting. And we will wait to see what the Commission says. But I would say that it's important to look just not at the individual trees, but to have a big view of the entire forest. So I do see where the Commission is coming from, and I can see why one would be concerned. Lastly, if I may answer the question that you've asked, more squarely, Norman, I do not think that we should change anything in terms of the law. I think the law itself is broad enough, as I've said, but I think there is an open question around the enforcement approach and the enforcement vehicle that the Commission can pursue in such matters. Thanks.
Great, Liberty. Thanks very much for that. Perhaps going on the similar theme, I can then turn to Alastair, who is as it were in industry, an industry representative. I mean, Alastair, do you have a view as to whether our market here, our digital market, is over concentrated and we have a competition problem because there's been lax enforcement in the past, or is it too early to make this call? And do you have any view as to whether our digital players are still constrained by their bricks and mortars players in the current market? So I'm sort of throwing you a number of, as it were, global issues to throw your way, and to perhaps just to get your view on it. Thanks.
Thank you very much indeed, and thank the Institute and the Commission very much for setting this up. I feel very honoured to be invited to talk. And I think I'd like to go back to something that Liberty said just a second ago. He said the industry doesn't necessarily know what the market will look like tomorrow. I think where we sit today in the middle of COVID is an absolute perfect example. E-commerce has jumped, has leapt 5 years in a short 8 months, from being a small and it still is small, part of the retail market to being a little bit bigger. Maybe perhaps something between 5 and 8% of the total e-commerce retail market for business to business in South Africa. This is a very big jump, and I think we need to be very aware of the enormous changes that are happening. COVID was as the Germans would say, a zeitgeist, a world spirit, which has changed an enormous amount. Therefore, what the Commission is proposing, a mapping, I think is incredibly important, so long as that mapping is very proactive and continues to be mapped. It's not just set down on a piece of paper and then left, and that's it. As far as the discussion paper is concerned, may I say that from some years of experience, there is nothing quite so pleasurable and satisfying as seeing a very well researched and thought out paper and being able to comment on it. So I'm really grateful for the Commission for their extremely good work. I think it's absolutely superb. Mr. Chairman, you mentioned this issue of bricks and mortar and the competition. Yes, I mean, within e-commerce, certainly the bricks and mortar companies, even those who in February, for example, or March, were not in the e-commerce market, are now in the e-commerce market. They've moved, they've put themselves online, et cetera, et cetera, et cetera. So you can't look at the e-commerce market as just a small sector of industry without looking at it holistically within the whole of retail. And I think we have to be aware also that there is a very wide range of competition already in South Africa. The University of Amsterdam did a study at the beginning of this year on Africa and what they called e-marketplaces. They found there were over 600 e-marketplaces throughout Africa. 106 of them were here in South Africa. Most of those are very specialized. They are the We Buy Car type of platform. There are some which are what we would in the old days call classified ads, where consumers put up advertisements, et cetera, and you buy whatever it is, bicycle wheel that you're looking for or whatever. And then there are around about 20% which are selling business to consumer goods. And these are organizations like Loot or Zando or Take a Lot, et cetera, et cetera. So even within the platforms, there's a very wide range of speciality. There are also e-shops, specific e-shops, which you can go to buy products. We think there are around about 8,800 of those, according to an organization called Build With It, which is an American company that looks at how e-commerce is created through platforms like WooCommerce and Shopify. And then there are these multitude of small players. And when I wrote our comments, I suggested that around about 30 to 50,000 of these small, mostly sole traders in South Africa. I've since subsequently revised my views very much. I think there are at least 100,000 of these companies. And so what you're getting here is what is sometimes known as the marketplace power situation. If you look at India, for example, where they have over 700,000 small players, and then a number of very large players. And as Jonathan said, and I love that, he said there are giants in different sizes. So we have to also break the market down to see what sort of sizes, what sort of marketplaces there are, and where the giants might exist or might not exist. We feel very much that it's incredibly important to have a vigilant and careful look at what's going on in the rest of the world too. We don't live in a world where it's just North Africa. We live in a global world. We live in these big tech worlds, et cetera, et cetera, et cetera. So my answer to your question is no, I think it's far too soon yet to actually start identifying people, organizations, companies, which might be dominating, because I think the marketplace is still changing so enormously. And I think a proper mapping and proper data is much more needed. And we are working with the Department of Trade and Industry and with 5 universities, including WITS, to try and improve data. We know very little about the market. And I think it's just a good example was within the couple of months that I wrote the response to the Commission's paper. And now I've really revised my views on good evidence and doubled the number of small companies at the very least. And maybe I'll come back to that later. Thank you very much.
Okay, great. Thank you, Matthew. And that's very interesting to see how just in that short period of time, one's data changes and one's views change with that. Let me then go on to an entirely different topic, and if I can ask Xolani then to put on his video. Xolani, you still with us, Xolani?
Yes, I am.
Okay, thanks, Xolani. Xolani, you know, the Commission has made certain recommendations on collusion, and that really takes us into the sort of the esoteric world of detecting collusion through the use of algorithms. So at the same time as saying it's going to enhance its capacity to catch people by using algorithms, it's also, as it were, adopted a guidance strategy. And so I've just extracted some paragraphs from its guidance strategy. So it says that firms operating these digital markets should avoid developing and sharing algorithms that allow competing firms to simultaneously adjust prices based on the inflow of market data. It says avoid developing and sharing algorithms that lead to price setting, market allocation, or collusive tendering. And thirdly, to avoid using data to set prices amongst competitors and data analysis to monitor pricing agreements amongst competing firms. I mean, do you share their view that algorithms are something that you know, if 2 firms were to provide the same software package, that this would, in a sense, constitute collusion in terms of our act as it is? And secondly, depending on your answer, is it useful for the Commission to be giving this guidance, or are they, as it were, overreacting in the way they're giving guidance? In other words, are they telling you not to do something that's not necessarily harmful? What's your view on that?
No, thank you, Chair. I should be careful in terms of what I say so that when I see Hardin, I don't cross the street onto the So I mean, my sense is, I mean, going through the strategy paper is that a lot of it, at least the examples given, do sound to me as if they are what one would call first principles guidance, which can be applied really to conduct, you know, outside of digital markets. And so it's really industrial economy guidance, and perhaps may benefit from tweaking to apply more in the digital economy. You've got to sort of understand that, you know, the economy, of course, or the digital economy exists along a continuum. So what that is that you've got the industrial economy with some aspects of it that exist, that have been automated and exist in a digital world. And then you've got what is properly construed as the digital economy because everything is happening completely on a platform, right? So in circumstances then where we are talking about, for instance, where you've got good old collusion, market allocation, price fixing, that simply has an algorithm to monitor that no one is cheating and its implementation or even retaliation. That's good old fashioned industrial economy stuff that just happens to have some form of tech sitting behind it to enforce it. And so I don't necessarily think that, in a digital paper that's necessarily takes us forward. That's something I think the Commission already probably has the competence and the tools to detect. It might, of course, want to beef up its ability to do so. But I do think that's just that's old economy stuff. But of course, I suppose it also does, of course, if you're talking about sort of more bespoke platforms or tech or algorithms that use the same data and are likely therefore to produce the same outcomes, perhaps the Commission there might have a reason, at least optically, to just give it a first look and see what's going on. But taking into account, of course, that one shouldn't, I think, take the view of thinking around a per se prohibited conduct in circumstances where we do have oligopolistic markets in South Africa. And so conscious parallelism is really a reality in our market. And it's not an unlawful activity by any stretch of the imagination under our law. And so to take a per se rule approach would perhaps be too blunt an instrument. Where I think it probably starts getting a bit more interesting and where perhaps the Commission is looking at and perhaps wants to give more guidance is in circumstances where you have machine learning, artificial intelligence. So you write a piece of code and so do your competitors. And you've instructed this piece of code to learn over time in order to maximize pricing and the like. And it over time starts to learn and itself starts coordinating with other algorithms in the market because it has figured out that the best way to do this and achieve the best price is actually through coordination. And then I suppose the Commission's question is around where would liability lie? Do we need to introduce, is the current law enough to do that? Or do we need to introduce sort of strict liability to deal with that approach? Is it the developer who would be responsible for it? If, for instance, I don't know anything about technology, I just asked an independent third-party developer to develop this thing for me, or is it that I, as the beneficiary of this, the business who benefits from that collusion, who is held liable? I do think it should be the business and not the developer. But nonetheless, I think that's where we should be looking at. So more really into the digital economy rather than dealing with old economy, industrial economy that just has a tinge of tech behind it. And of course, what I do think we need to perhaps, again, to try and avoid a situation where we blunt innovation and people are too scared to innovate is, as I've already said, to try to move away from looking at things through the prism of a per se prohibition. But on the other hand, I do think simply because of the rapid pace of change, the Commission may well be justified to start thinking along the lines of introducing presumptions in favor of the regulator, of the competition regulator, so that there is a reverse onus on parties if the commission has at least met some level of prima facie evidence that there may be something here that is untoward. And I think that is something that obviously we've now become familiar with as lawyers, and probably our clients are also becoming more familiar with it, at least since the advent of the amendments to the Act, where a number of presumptions have been introduced. So that so that's not something completely foreign. So it does then seek to balance innovation on the one hand and concerns that the Commission legitimately could have around how these algorithms may work out. So I do think that we do need to acknowledge the market creating and pro-competitive impact that these algorithms might have, because they are useful in terms of creating markets. They link buyers to sellers. It's just that the problem is sometimes the sellers may well be competitors at some other level, right? And so we need to be aware of that. But I do think that at the same time, we want to allow as much of that sort of trial and error to happen, but still allowing the authorities to be able to step in before too much damage is done. So on the crisp question, I do think that the paper probably will benefit from moving a bit away from sort of what already exists now, because we know that when we've got the tool to deal with it, it's not really very controversial stuff. These are, for me, are really just, good old-fashioned industrial economy, market allocation, market division, price fixing, with a tinge of tech. Let's deal with where are we going to from here. And I think that's probably the more interesting aspect for the Commission to deal with. Thank you.
Xolani. Well, I think the suggestion around presumptions in these things is a very interesting one, and something for the Commission to think about in follow-up draft, because I think that's a very interesting idea for trying to balance between these, did the firm do it or did the machine do it? Don't blame me, blame the robot. So thanks much for that, Xolani. Let's now go on to, as it were, our round two questions. Perhaps I'll go back to you, Alastair. The Commission has raised the idea of supporting national champions through industrial policy, and it says as part of industrial strategy, policymakers may provide subsidies or indirect support to local firms or innovative, etc., etc. In other words, all good things. But it then says national champions must face competitive rivalry and reciprocate through investment and performance. Reciprocal control mechanisms can be incorporated in national industrial policy frameworks to ensure that economic outcomes are in line with performance targets. Now, I would point out, and this is a lawyer's issue, there is already in the existing legislation a provision, what we sometimes call the national champions provision. It's one of the public interests, and it says that one of the public interests that you may take into account in a merger is the ability of national industries to compete in international markets. Now, to cut it down to really what's being said here is often the debate around national champions is that you allow a national champion, you give it certain regulatory deference because it's going to become a big guy in your local market, so it can, as it were, fight abroad, but probably consumers locally will pay higher prices for that. Is that realistic in the digital market where we're talking about these much larger ponds where we're beyond borders in a sense? What's your feeling about that? What sort of industrial policy should be there, as it were, to give some firms a leg up? Or should we leave the market to sort that out?
Thank you very much indeed, Mr. Chairman. And can I just quickly go back to a point that Xolani made just a second ago, where he was talking about how blockchain and things like this work, algorithms work. I think it's very important to remember that, like all these things, if you put good information in, you get a good solution, whatever that solution happens to be. if you have bad information, then it's going to be a bad solution. So companies that may have indeed the same algorithm, but if they have a different type of information, they will get different answers. So again, we need to come back to this thing that it is a very complex market that we work in. I don't think it's just a small bit of tech. I think it's a very large piece of tech that we're looking at. And this brings me to your question, which is that when we're looking at the digital economy, and we're not just looking obviously at e-commerce, we're looking at fintech, we're looking at payment systems, we're looking at inventory and warehousing in case of e-commerce, we're looking at delivery and logistics, which is not even necessarily particularly technical. We're looking at software solutions, which are very technical. So the paper covers all these directly or indirectly. And I think we have to ask ourselves then, which national champion for which aspect of the sector we're looking at. It would be, I think, very early in the day to say, oh, we need to take one company and promote it, etc. Because this brings us on to an issue of not just a global market, but also the African Free Trade Area, which is being set up as we speak, and which will be launched on the 1st of January next year. Do we want a national champion to champion throughout Africa? Jumea, a Nigerian company, tried that. What they ended up with was 11 different companies in 11 different countries. So I think this idea of a national champion in the case of e-commerce would certainly be too soon. What I do think, though, is that we do need national championing of the digital economy through consistent and effective investment in key issues, and in particular in assisting the gathering of better data on e-commerce and on education, upskilling, training, and these sorts of things. So national championing, yes. National champion of what? which part of the sector are we talking about, etc. Thank you very much.
Thanks. Well, I think it's a very nice way of actually putting it. And maybe if there's a look at a redraft, that's a very good way of phrasing, because I actually think that's what the Commission means, is national championing rather than national champion. So I think that's a great way of explaining it and putting it. So if I can then go on to, let me go back to Liberty. Liberty, now I'm going to sort of move on to you and a question about dominance. And you know, you've been in some of the bigger dominance cases for the Commission, and I think you've been on some dominance cases for I don't want to say the other side, but let me politely say the private sector. People have been charged with charging too much too soon. But let's go back onto the Commission's recommendations on abuse of dominance. The report seems to look, and maybe perhaps I'm not giving it a fair reading, but it seems to approach dominance from a sort of traditional approach to dominance and not looking at some of the more interesting ideas that have come about. You know, there's the German Facebook case, which looks at Facebook as privacy as an exploitation issue relevant to competition enforcement. So although it's mentioned in the report, it doesn't seem to come through as one of the recommendations that they're going to be looking at that. And the Commission seems to have ceded that field to other regulators. But should abuse be looking at in this area in a different way, in a more out of the box way than has been looked for traditionally? What's your view on that?
Thanks, Norman. Let me start by maybe just going to the report itself and just thinking about it more carefully. First, the Commission report states that there have been a few cases that have been investigated involving digital markets, and that none of these cases have led to a conviction. In relation to a conviction, of course, this claim is not strictly true. The CompuTicket case is a case about digital platforms. Simply put, it was a case about how to think about competition among multi-sided platforms. And it led to a conviction by the tribunal and by the court. So if you think about that case, it was about exclusion in multi-sided markets, and the issues of debate were in CompuTicket about the same common digital market problems that you find in any other case, how to identify harm when you have these multi-sided markets, whether the market itself has tipped. So that leads me to today's biggest talking point in the US, the ongoing Google case. Like the CompuTicket case, Google is alleged to be monopolizing out of very familiar strategies. So in your language, Norman, out of the traditional strategies that relate to exclusion. The analysis there focuses on how, or will focus, like any other case, will focus on how the dominant firm grew its dominance and what strategies it has taken to maintain that dominance. So if we know that a firm is dominant, it has a high market share, then the question is why? In the CompuTicket case, it was about exclusive contracts. In the current Google case, it's about tying, it's about contracts, it's about familiar strategies. So in both these cases, I use them just to illustrate that the allegations are being framed within the existing law in South Africa, in the US, in Europe. So in a way, the traditional way of thinking about these cases seems sufficient. I think it's important to note as well that when we are asking the question, why has a dominant firm gained or maintained its dominance, there is no limit on the way in which we formulate our theories of harm relating to exclusion. So it's not an issue of the law, but it's just an issue of what theories of harm are thought about and how they're expressed. In some of these cases, the theories of harm have become so profound that we now teach them at the university. And if you think about the mechanism of exclusion, predation versus exclusive dealing versus tying, these mechanisms themselves are often interchangeable anyway. So a focus that is in law that's focusing on exclusionary conduct is supported by economics, but it doesn't have to focus on the mechanism. So if I may say something about what Alastair and Xolani have spoken about in terms of algorithms, and I use the example of the ticketing case, the CompuTicket case. When we think carefully about algorithms, they're just math, they're just code. And I think that adage is useful to keep in mind. And I say this cheekily to my colleagues because the exclusionary strategy is observed in the outcomes, and the law rightly focuses on the right question, the outcomes. So unlike other jurisdictions, in my view, South Africa stands different. If you look at the legal developments up to now, the decisions of the tribunal and the court, they have not sought to meritoriously limit exclusionary conduct cases being investigated, or that may, and that we may get worried that such decisions or legal developments may now have consequences for the digital markets. In fact, it's otherwise. All of this is to say that the Commission has a duty to attack monopoly power whenever it sees it, to advocate, this is the spirit in which I read their paper, to advocate for an update in doctrines that conform to modern economic theory. And I see this report as an advocacy approach by the Commission. But at the present moment, I am not sure that one can say clearly that there is a need to update, if there is a need to update the traditional way in which we think about exclusion based on modern economic theory. On inclusion, I think the focus on buyer power, it comes up in the Competition Act, and you'll see this also in the buyer power guidelines that have been brought up. They designate online markets. The German case that you identify, Norman, is very interesting. It relates to Facebook's data collection behavior, which is seen as an exploitative abuse of a dominant position. As I understand that case, the issue was about Facebook collecting and linking user data from its own suite of services and from third-party websites. And the German competition authority said that that consent of data processing must be voluntary. So one cannot make it a precondition for the use of Facebook services. So it's the combination of data sources that that brings about the gain in market power to Facebook. And the competition authority focused its assessment on a concept of unfairness. So unfairness on the data protection policy. So unfairness as a result of Facebook's data collection policy, because it invades a user's right to privacy. Unfairness has been introduced in our competition amendments, but only in relation to buyer power. I remember when we were in the Ministers' Advisory Panel trying to recommend amendments, we suggested that fairness be brought also in excessive pricing, in the excessive pricing prohibition. That did not win the day. But in the German case, unfairness leads them, the concept of unfairness leads them to find against Facebook. So when I look at the Facebook case, I think it challenges the broad concept of harm in abuse of dominance cases by moving it beyond efficiency. Even with the amendments now as they stand, they are largely on this concept of balancing harm with efficiency. It's only the buyer power provision that goes outside that realm into a fairness and fairness zone. So I think it's interesting as well that if you think about the Facebook case, Germany has sought to codify the lessons from Facebook, the Facebook abuse of dominance approach in its competition law amendment process. And when you look at those proposals, they are talking about a rational consumer apathy being one that needs to be protected in competition law. So I think that there are some learnings that perhaps the Competition Commission can pick up on. But when I look at Facebook, I see it raising even interesting points around services where consumers don't pay a price, and that challenging how we think about predation, how we think about excessive pricing. In fact, in the Facebook case, one of the allegations related to excessive pricing, and the argument was that the argument fell apart because data and money are not comparable assets. Unlike money, data can be spent over and over again. Consumers did not, and do not grasp the consequences of disclosing data, as well as the consequences of spending money. So the exact welfare implications of transferring personal data cannot be reliably quantified. So this leads me to a second point, which is the point that emerges in the Commission's report, where one sees these problems that relate to abuse of dominance and digital markets as just as sometimes beyond competition law. Hardin mentioned in the beginning about network effects. I think it's a fact of life, network effects. The more today everyone is using a digital platform, and we get more value in using that digital platforms we are using. In some markets, you could even argue that some markets have tipped. I don't think it would be incorrect to think of, some markets that we're very familiar with as having tipped. So these dynamics make, challenging anti-competitive conduct using abuse of dominance quite challenging. And we know that some firms will target small companies or small competitors or potential competitors, but it's hard to devise a remedy to restore competition. And then I think the Commission is right to think about regulation or looking beyond competition as a way to reduce barriers of entry in these markets, because the restoring competition and preventing future competition law violations requires a remedy that focuses on barriers to entry. So let me leave it here for now.
Okay. Thanks very much, Liberty. If we may just have to ask the remaining two, just to keep it a little bit. We're running slightly short of time, and they've all been very useful discussions. We are slightly short of time. But let me go on to Xolani, and it arises from what Liberty is saying. In other words, we've got these problems which the law doesn't entirely deal with. They're new problems, and there's quite a lot in the report that the Commission says that market inquiries will be useful. Market inquiries will be useful for that. Is the Commission, in a sense, and let me ask you a sort of a slightly provocative question, is the Commission trying to sneak some of its harder cases into the market inquiry? In other words, leave this for another day. Whenever we've got a problem, we've got a political problem, we say Commission of Inquiry. Is the market inquiry being used in the same way, because it's got these much more broader provisions than are in the more traditional Section 4 and Section 8 and Section 5?
Thanks, Chair. I must say, I think that in this case, the Commission has no other option but to have a market inquiry, because I think, and quite commendably so, I think if there was an example of regulatory humility, this is it. Because the Commission, I think, quite rightly acknowledges that it has some knowledge gaps in terms of understanding the digital economy. And that the Commission still has to gain a proper view of the digital economy, in particular as an ecosystem. So that's from infrastructure to the services that overlay on that infrastructure. And then, of course, then you need to add the startup ecosystem, the venture capitals that support that ecosystem. And what are the drivers of innovation, and are those drivers changing? I have the benefit of, from time to time, sitting with a lot of the guys who in the Silicon Cape sort of ecosystem, and the driver of innovation, 5 years ago was you wanted to be bought out by Google or Facebook or Amazon, or you wanted to be the next Google, the next Amazon. These days, that has changed somewhat into, we don't want to be the next Google, the next Amazon. We need to have market creating innovation, i.e. there's nothing that exists currently and we're going to, because that offers the most returns, because that's exactly what Google and Facebook and them did. They weren't, those products weren't in the market. So they weren't competing with anyone, and that's how you grow. And so I think the Commission has I think quite rightly acknowledges that we need to understand the existing ecosystem. Are the drivers and pull factors, are they changing? And then, then you can sort of move from there, because, and precisely because the existing, large firms, they were disruptors. And so what then typically happens is that they tend to blend different markets. And so it's very difficult then to pigeonhole what it is that they actually are, notwithstanding the decisions of the European Commission and other regulators, Google and the ACCC, for instance, Google, that would not see itself as a news outlet or as a shopping engine, right? And if we move, and so when you start to try to pigeonhole them whole into that particular market, they fight back. But even if you leave aside Google, and you look at the one sector, at least in South Africa, that has experienced the most disruption from technology, which is the financial services sector. I mean, you know, fintech is absolutely pervasive. And I mean, what was interesting is that just earlier this week, we had Vodacom come out and announce that it is the 5th largest insurer in South Africa from a profitability perspective, right? Now, this is an MNO, yet it's the 5th largest in short-term insurer. And even the core of financial services, or if you just look at, for instance, banking, even the core of banking hasn't escaped disruption. You've got Time Bank, you've got Bank Zero, and of course, to a lesser extent, you've got Discovery Bank. And I say to a lesser extent because, you know, Discovery Bank is as big as it is, but it benefited from its previous credit card with FNB. So that's a slightly different entrant. And so with the exponential change and uncertainty, I think it will be difficult then for the Commission to undertake robust ex-post regulation if it doesn't have a deep understanding of the digital economy, incentives, the regulatory framework, and how they all fit in together to give rise to the effects or the outcomes that it has a concern, you know, the observed outcomes that it has a concern about. And then finally, I think, and this is the one point, I think, whilst the Commission seems to have settled on the idea that big data in and of itself is a source of market power, I think that is by no means a settled view outside of Mulayo Block C. And I think that, you know, not all data is equal. And not everyone is blessed with the ability or the resources to make sense of that data, whether it's, you know, to get high quality data that one could then derive market power from. And I think then precisely for those reasons, the Commission, it's too early to then say that the existing unilateral conduct framework is inadequate. I don't think we have enough to come to that conclusion. But also, I don't think the Commission would have enough, to really go, into becoming too robust in its prosecution of observed conduct. The one last thing I want to say is that, what a market inquiry does, I suppose, is to resolve this tension between whether can you very neatly pigeonhole particular conduct into a particular section of the Act or not. But also what it does allow you to do, as sort of an advocacy tool, is, and then to say to market participants, listen, this is what we're seeing in the marketplace. Can you give us more information around it? Do we need to think about different tools, or are the existing ones sufficient? And of course, the new market inquiry provisions allow the Commission to do a lot more than it would in the old days, with far less evidence of problematic conduct. But that insight that the market inquiry would give the Commission, I think, is one that would put it in a very firm footing around whether is it in fact true that big data is in of itself a problem and therefore needs to be regulated in terms of the existing law, or is there something else that they haven't picked up yet? So I would be supportive of the Commission. Yes, one may look at it as sneaking in things through the back door, and certainly that is a concern with other market inquiries, but I think this one is probably the right way to go.
Okay, thanks, Xolani. So no sneaking in there. Finally, just to go back to Jonathan, and this picks up on some points that people I'm just looking at the chats here are making, is that a lot of the debate in the other jurisdictions is about whether you need ex-ante rules to deal with some of these issues in the markets, particularly issues like privacy and freedom of speech. And secondly, if you do have ex-ante rules, Does it suggest that you need another regulator, as it were, to regulate digital firms? And if you're going to have another digital regulator dealing with some of these issues, should they deal with all the issues, including competition as well? It's sort of a debate that the Commission has had for years with bodies like Ecommerce, who want to, as it were, deal with everything in their industry, including competition to the exclusion of the competition commissions. But quite often members of the public have approached the Commission to deal with their problem, even if it's in the house of some other regulator, because the Commission is seen to be the regulator that will stand up to big business. It's an unafraid regulator. So how do you see this issue? Do we need another regulator? Do we need ex-ante rules? I mean, it's a very complicated debate for me to ask for a very brief response to it, but just your thoughts on it initially, Jonathan.
Okay, thanks, Norman. And I will try and do it in kind of 2 minutes rather than more in order to get some comments from the exceptional audience that we have here. It even moves beyond kind of the interactions with ICASA, because it moves into, well, maybe like with the Broadcasting Complaints Commission, but it really moves beyond economic regulation into regulation of democracy more broadly. But I think we would distinguish between the effects on the democratic process and what relates to economic competition or economic regulation, even though a domain like privacy, and we've got some discussion of that in the chat, does easily encompass both. And to give an example here, firms are using privacy technologies, privacy enhancing technologies, in fact, to improve their business or market position, to increase the likelihood that consumers might stick with them, or to decrease the likelihood that they would move to others. So it's a very, very important interaction. And we do need to recognize that it's not just the POPI, right, the Protection of Personal Information Act, that there are privacy aspects in many other many other statutes, and therefore in many other regulators, to get to your question. And there we start talking about capacity and mandate of those regulators. So Deputy Commissioner mentioned the information regulator, obviously an important one in this space. But I think it's fair to say, just having taken over from the Human Rights Commission with a merger of the Access to Information Statute and the Privacy Statute, still, well, certainly in early stages of development, budget, experience, etc., which of course is actually par for the African course, and South Africa is a leader here. So I would say it's not a question of setting up a new specialist regulator, or even really a new unit within the Competition Commission. But Norman, your phrase was, to what extent has the Commission ceded the field to other regulators? I think, this is a really interesting space, but it's one where, I think, frankly, there's a creation of a new field. And it lies at the intersection of telecommunications, information regulator, consumer protection, and competition. Although, as Norman, you alluded to, I think it's fair to say the competition regulator, the Competition Commission here, is going to be the driver. And this paper, in my view, whether it's strategy or advocacy or policy, is an example of that. So yeah, I see the new structures, not so much necessary as new regulators, but I agree with some of the chat and elsewhere. We're talking about the African Continental Free Trade Agreement, certainly at the regional levels. We haven't actually mentioned Southern Africa, SADC. There are many interesting developments, model statutes, et cetera, in the digital economy there. So I think those are places where new structures may, and probably more profitably, could produce greater leverage and voice and enforcement. Because, going to one of the points Liberty made, there can be network effects on the enforcement and the policy side, as well as the private sector firm side. Okay, there's more to say, but let's stop there.
Great. Well, that's and I like your phrase about the network effects of regulators as well. It's a nice buzzword and a nice idea, which the Commission could take on board. Well, we're running out of time, so I'm going to say I'm not going to have a position to open the debate further to the audience, but there are some questions and comments in the chat which I would commend everybody to have a look at. But thanks very, very much to the panel for that very, very useful contributions that you've given us, and some very, very interesting ideas that are food for thought. But I think overall, Hardin, I think the Commission is receiving very good feedback from my overall impression of what is being said, and good for you guys. And hopefully we provided you some things to take on board. So if I can just to give a final concluding remarks back to our Director of the Mandela Institute, Professor Feroz Kachalia. Feroz, if you could come back online, and we'll then finish with you. Thank you.
Thanks, Norm. No, I just want to thank you all again. I look forward to working with the Commission, Hardin, in the future, and to thank each one of the panelists. I think we've had a very rich discussion focused very much on the competition questions. But it's clear even from this discussion that we also need a more comprehensive, a way of addressing the more comprehensive questions, both of regulation, say the intersection between, say, competition and privacy, consumer law. And I think the country needs a broader conversation about the implications of digitalization for employment, for economic inclusion, and it worries me tremendously that we I think are somewhat behind the curve in our country. So speaking for the Mandela Institute, we're looking forward. The Mandela Institute and Wits University really looking forward to supporting the work of the Commission, but really of all the regulatory bodies that are faced with the challenge of addressing the impacts, both positive and negative, of digitalization. So thank you very much. I'll be in touch, Hardin, with the Commission to take this forward. Let me also thank all of you individually, Alastair, Professor Klaaren, Xolani, I left anyone out, and of course, Norman. Thanks very much, everyone, and also to all of you who've participated in this extremely important and interesting discussion as participants. Thank you all.
Cool. Thanks, everyone.
Thank you very much.
Thank you. All right.
All right.
Thank you very much indeed. Good to meet you all.
Thank you. Thanks to all of you. Thanks a lot.
Thanks.